Goode's alleged misconduct is reportedly related to interactions with Proctor. In fact, oh, good tea. In fact, according to newly received documents from the Norfolk District Attorney's Office, Goode and Proctor are close longtime buddies who frequently exchange vile messages while both served as police officers. After Karen Reed's acquittal, she had to resume the wrongful death case brought by the O'Keeffes. The O'Keeffe family, in a variety of different ways, and as representatives for the estate and what have you, brought a wrongful death case against Karen Reed and against the Barrs. The civil federal case is Karen Reed suing Proctor, Tully, Buchanan, the McCabe's, the Alberts, and Higgins. But we're also seeing these fights for discovery that are kind of nuanced, because when you're looking at like the Proctor phone situation, the Proctor personal phone problems is stemming from criminal cases in state court for defendants, not Karen Reed, where Proctor was the investigating officer. Then when you get to the civil wrongful death case, there is also an ongoing fight over discovery. The Proctor personal phone stuff was turned over to Karen Reed's team with regard to being able to use it in the civil wrongful death case where the O'Keeffes have sued Karen Reed versus the civil federal case where Karen Reed is suing. Karen Reed's team, and we covered this Tuesday, is asking for an embiggened order to allow them to use that to also sue the Town of Canton and Massachusetts State Police. There are different hurdles you have to jump through to sue government entities versus suing individuals, and that suit has not been brought yet. But we learned from those filings that that is being contemplated. I bring that up now because we are going to be talking more about a discovery fight with Canton. We also need to update what happened with the emails or email. Emily, what email? That reply all email. So you'll remember that there was a fight going on because Karen Reed's attorney was arguing that the O'Keeffe's attorney should delete and destroy, not seek and destroy, delete and destroy the email that Karen Reed had accidentally hit reply all. That attorney was like, this was my bad. I forwarded that information to Karen. She hit reply all, didn't realize that plaintiff's counsel was on that email thread. This was a error. And we told them like within 45 minutes, by the way, that wasn't meant for you. Can you please delete it? And the attorney for the O'Keeffes was like, nah, you sent it to me. And they had a hearing on it. This is normally one of those items of professional courtesy. It's clearly not meant for you. You would want the same courtesy if the shoe was on the other foot. So extend the courtesy. Instead, it had to go to hearing, and they were all fighting it out as like Brady Bunch boxes on a Zoom call. The court has made a ruling on that. And so we're going to look at that first. So Massachusetts does a few things that are quirky. And one of those things is that there are times that the court just endorses the motion instead of issuing a written order. That's what we're going to take a look at now. It's like a photocopy of a photocopy of a photocopy. Yes. So this is the court's endorsement, which means the court has typed their ruling onto this motion. This is Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication. This text box up here with the signature, that's the court's order. March 27th, 2026. As noted in the Charm case, a client who seeks to preserve the attorney-client privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Although this defendant did not meet that responsibility, the importance of the attorney-client privilege in our legal system outweighs that failure. Defendant's motion seeking deletion of the email and any copies is allowed. Why you shouldn't have reply all. The court's just like, Although plaintiff's concern about potential use of the email for impeachment purposes may appear to the defendant as unfounded, If such concern becomes reality, the issue is preserved as the email remains under seal with the court. Plaintiff's attorneys don't get to keep a copy. They are ordered to destroy every copy. That's going to have to go on, I trust that you do it when you say you do it, or you can end up completely sanctioned. And a copy of the email is under seal with the court, and the attorney for the plaintiff has already read this. So the court says the concern is if Karen Reed says something in the course of deposition or the course of all the rest of it that is contrary to maybe what's in this email, then the issue can come back up before the court and say, no, but I get to use this as impeachment. That's where the court says that issue is preserved. New filings. Let's go. All right. The court is granting a motion to continue. All right. This hit the docket today as being allowed by the court. Do you notice that the way the court did the court ruling here? The ruling is literally the judge just handwriting allowed with the date stamp on it. This was filed on April 15th, granted by the court April 16th. That handwriting is the motion being granted. Now comes the Town of Canton with the assent of defendant Karen Reed through her counsel. Well, at least everybody agrees. Defendant Reed's motion to compel the Town of Canton to produce documents pursuant to non-party subpoena currently scheduled for Tuesday, April 28th at 3 p.m. be rescheduled to the following Tuesday, May 5th at 3 p.m. or sometime thereafter convenient to the court. As reasons thereof, counsel of the Town of Canton will be out of the country due to pre-planned travel during late April and early May and is unavailable. That's getting continued. Well, I guess as we look at the fight over discovery with the Town of Canton, we now know that that hearing will be held on May 5th as it was continued. Well, the continuance was granted on April 16th. Let's take a look at those motions now, because that is really what we wanted to talk about, is the fight over discovery with the Town of Canton. Remember, Karen Reed still intends to sue Canton. Karen Reed's motion to compel the Town of Canton to produce documents pursuant to a non-party subpoena. Canton's not a party to this lawsuit. Defendant Karen Reed requests the court to compel the Town of Canton to produce all documents that are responsive to the subpoena that Karen Reed served on it over a month ago. The subpoena seeks documents relating to Canton Police Department's investigation into Sergeant Sean Goode. We talked about this when it initially came up. November 4th, 2025 is when he was suspended. The subpoena seeks documents relating to Canton PD's investigation into Sergeant Sean Goode's alleged misconduct, which led to him being placed on administrative leave in late 2025. Reed's counsel has been conferring with the town's counsel in good faith for months about these documents. Initially, the town's counsel expressly represented that the town did not possess documents that are responsive to the subpoena, but now, months later, the town acknowledges that it does in fact have documents, but objects to producing them. However, the town has not asserted any objection that justifies withholding the requested materials, and its conduct further delays the party's ability to move this litigation forward. The documents that Karen Reed seeks are well within the scope of Rule 26. I wonder why they need to go through the Town of Canton and not the police department. It just might be that that's who the record keeper is for the police department. That would be my guess. Reed respectfully requests the court allow this motion and order the town to produce all documents responsive to Reed's February 10th, 2026 subpoena within 10 days of the order. Your Honor, we have been asking them since February. Let's take a look at the memorandum of law connected to this motion. Defendant Karen Reed's memorandum of law in support of motion to compel the Town of Canton to produce shit that they should produce. I summarized the title just a little bit. Defendant Karen Reed respectfully requests that the court compel the Town of Canton to produce all documents responsive to the subpoena. Reed served it over a month ago. That subpoena seeks documents relating to the Canton Police Department's investigation of Sergeant Sean Goode's alleged misconduct, which led him to be placed on administrative leave in late 2025. Reed has now served 2 subpoenas on the Town of Canton seeking documents from Canton PD. Reed served her first subpoena on the town in July 2025, and the town produced certain Canton PD documents in response. Oh, look at that! They got some of the documents. That response is not being challenged here. However, in the fall of 2025, Reed learned that Goode had been suspended from Canton PD after Reed's acquittal and that the town was investigating him for alleged misconduct. In a phone call with town's counsel, the town's counsel informed Karen Reed that the town did not have any documents relating to the investigation or Goode's alleged misconduct other than the letter placing him on leave. When Reed's counsel repeatedly attempted to confirm that representation in writing over the course of several weeks, the town's counsel refused to respond. Oh boy. Goes on to say that later other attorneys representing the town informed Reed's counsel that the town may in fact have additional documents related to its investigation. So weird. But that the existing subpoena did not specifically cover those documents and that the town would object to producing them in response to that subpoena. Okay, well, we'll just issue a new subpoena. Reed's counsel served a new, more specific subpoena on February 10th, 2026. Right, the town of Canton doesn't have to embiggen their understanding of the subpoena to make it work. New subpoenas proper. In the context of Rule 9C conferences, Reed's counsel proposed that the parties discuss a compromise whereby the town would produce at least some of the relevant documents or produce documents subject to confidentiality restrictions to address the town's concerns about its ongoing investigation. Look, as annoying as my nosy ass finds that, that's fair. The town's counsel represented that he would consider this proposal, but never followed up, except to send a standard Rule 45 objection letter and continue to refuse to produce a single document. Oh boy. We're not going to do it under this subpoena. Sends new subpoena. We're not going to do it under that subpoena either. As it stands now, the town objects that Karen Reed's request for documents relating to the investigation of Goode's misconduct are overbroad, that those documents are irrelevant, and that it will not produce documents related to an ongoing internal investigation. The court should reject the town's objections. In this case, plaintiffs allege, among other things, that Reed created a false narrative that the police investigation into the O'Keefe's death was corrupt, biased, and designed to frame Reed. Goode's conduct is directly relevant to this issue because he played an important role in the initial response to Mr. O'Keefe's death and, as a result, Karen Reed's criminal prosecution. He answered the originating 911 call, was one of the first police officers on scene, testified at Reed's first trial. Goode was a close friend of lead investigator Michael Proctor. It's a fair question if one of the initial responding officers also knows that the MSP trooper who's now in charge of this investigation might have a conflict. Because one would hope that you would look at that and be like, hey, Town of Canton has a conflict. You also probably have a conflict. We should send this elsewhere. So I think it is incredibly relevant to the civil defense that all of this was corrupt from the beginning. And she's allowed to pursue discovery to do that. And in this lawsuit, they can't say that Karen Reed brought this lawsuit to go fishing for discovery to sue everybody, because she's the defendant here. They go on to say that Goode was also a close friend of lead investigator Michael Proctor. Goode's alleged misconduct is reportedly related to interactions with Proctor. In fact, oh, good tea. In fact, according to newly received documents from the Norfolk District Attorney's Office, Goode and Proctor are close longtime buddies who frequently exchange vile messages while both served as police officers. In a lot of cases, if the defense was talking about vile messages, I might be like, okay, well, are we talking about Bryce and Eric texting each other about an open marriage? Like, I will side-eye that in a lot of cases. Are we other uses for your throat? What kind of vile messages are we talking about? Not in this case. Not in this case. After we've seen what we've seen, not in this case. They go on to say, thus, documents related to the town's investigation into Goode are relevant to the claims and defenses in this action and are discoverable. They go on to say, moreover, the town's assertion that the requested materials relate to an ongoing investigation is not a valid basis for refusing to comply with the subpoena. The town's investigation is an internal personnel matter, not a criminal investigation, in which disclosure could risk jeopardizing a prosecution. Conclusion: make them produce them within 10 days. Let's see what they were asking for. Document requests. All documents, video, audio, recording, communications, including all things, covering the disciplinary investigation of Sean Goode. I don't think that's overbroad. They've limited it to the investigation of Sean Goode. How is that overbroad? They narrowed it down to that investigation, including CPD and the town's investigation of Sean Goode. All communications between Sergeant Sean Goode on one hand and Michael Proctor, Kevin Albert, Brian Albert, Nicole Albert, Chris Albert, Julie Albert, Colin Albert, Brian Higgins, Jennifer McCabe, Matthew McCabe, Allison McCabe, or Carrie Roberts on the other from January 28th, 2022 to present. I mean, it's limited as to time from the time of the crime. I don't know if that's overbroad either. I don't know if they have all of that in their possession. They might not have Sean Goode's communications, but they could have his work phone, his work emails and stuff like that. That's appropriate. Let's go to the Town of Canton's response to the request from Karen Reed. Town of Canton's opposition to defendant Karen Reed's motion to compel the Town of Canton to produce documents pursuant to non-party subpoena. As relayed in the town's initial objection to the defendant's subpoena, the defendant's subpoena is overly broad, not reasonably limited in time or scope, is not reasonably tailored to produce discoverable information, seeks records and information that are wholly irrelevant to the underlying claim. Boilerplate. These are boilerplate objections. Great. In late November 2025, the defendant began contacting the town and the town council, seeking new records related to Sergeant Sean Goode being placed on administrative leave by the town. Well, that's why they're seeking it from the town. The town placed Sergeant Goode on paid administrative leave in late October of 2025 and coordinated with town council to retain an independent third-party investigator. That's interesting. To conduct an internal affairs investigation on behalf of the town. Okay, but they can't necessarily go to the third-party investigator and ask for the documents because the third-party investigator is going to say, just go ask the town. Paid leave. They responded with the letter, and then they're going from there. Defendant's counsel then proceeded to send a barrage. Oh no, the emails, too many emails. A barrage. We've been barraged by emails. Defendant's counsel then proceeded to send a barrage of emails to town council demanding attestations and declarations of whether other documents may or may not exist. The defendant's assertion that town relayed that it did not possess responsive records, but now months later, the town acknowledges it does have documents is deliberately misleading and offensive. Here's how I read that. We didn't have the documents because the investigation hadn't started yet. And once the investigation started, we started getting documents. So it might also be true that they didn't have documents at the beginning and now have documents. But it's also disingenuous to slice that with, but we don't have any documents. If you know the documents are coming, if you know an investigation is ongoing and that you will have documents, is it 100% true to say, well, we don't have documents right now? It's true, but it leaves out context that narrows the scope because you know that they're going to be coming, right? The town and its council operated in good faith to produce the limited responsive records it had in its possession. Excuse me, can I fix that for you? The limited responsive records it had in its possession at that time. However, as the investigation developed, the concerning timing of Sean Goode's administrative leave letter appearing online and defendant's counsel's improper attestation demands necessitated more formal objections to the defendant's request for investigative materials. You guys, the public knew about the letter because it ended up on the internet. Am I overreading this, or are they insinuating that defense counsel leaked the letter online? You let me know what you think, because it seems to me that they are insinuating that defense counsel is somehow involved. Prior to the issuance of the new subpoena, counsel for the town and defendant engaged in discussion to narrow the scope of the requested materials so to not hinder or impact the ongoing Sergeant Goode internal affairs investigation. They go on to say, in a flagrant contravention of those discussions, however, the defendant's February 10th, 2026 subpoena sought exceedingly broad records. Argument. The defendant's subpoena is impermissibly broad and seeks irrelevant materials. The defendant's motion suggests that it is simply seeking records regarding the current internal affairs investigation regarding Sergeant Goode. As detailed above, however, the subpoena in no way limits itself exclusively to the current investigation and seeks records for all documents concerning any disciplinary investigation of Sergeant Goode. Oh. So are you indicating that there might be multiple investigations? I suppose that investigations from like 15 years ago, if they exist, would not be proper. But would this need to be limited? Like, are we arguing this because there's something responsive, or are we arguing to delay? I don't know here what the answer is. There might be no other investigations and they might be arguing to delay. I guess they're asking to narrow the scope to disciplinary investigation of Sergeant Sean Goode relating to his suspension in 2025 is maybe the language that they would prefer. But it's civil discovery. You're allowed to cast a wider net, and then the court narrows down what can be used afterward. They go on to say it seeks all communications surrounding any report or alleged misconduct of Sergeant Goode and communications between Sergeant Goode and more than half a dozen non-town employees for more than 4 years. I mean, if those conversations are on his work phone or work computer, then yeah. Such requests are exceedingly broad and unduly burdensome upon the town and seem directly tailored to try to obtain attorney-client communications. Huh? Who's attorney-client communications? They seem directly tailored to try to obtain attorney-client communications and or attorney work product materials regarding the current investigation. I think that's a little bit of a stretch. The defendant's motion makes no attempt or sufficiently establishes the need for such miscellaneous records not related to the current Sergeant Goode investigation or the town's internal communications and other documents regarding appointing an independent investigator. They go on to say the defendant's motion fails to articulate any relevancy whatsoever. It simply insists that Sean Goode was one of the initial responding officers to Mr. O'Keefe's tragic death on January 29th, 2022, that Sergeant Goode and Michael Proctor are, quote, close longtime buddies, and merely concludes somehow that, quote, documents related to the town's investigation into Goode are relevant to the claims and defenses in this action and discoverable. However, the current investigation, which did not even begin until nearly 4 years after Mr. O'Keefe's death, does not involve any allegations remotely related to Mr. O'Keefe's death. You're really trying to split hairs on that one, though, because if it's related to Proctor, then it's related. And if it's not related, then it won't come in. But they have the right to get to that information. At the close of the investigation, the town anticipates having an investigatory report or summary. I mean, I would hope you have more than a fucking summary. And or summary regarding the investigator's findings and conclusions. As is asserted by the defendants, barring any statutory exemptions, that report would generally be considered a public record and readily accessible to the defendant via a public records request. I don't know if anybody trusts that this report is going to get done in sufficient time that it can be FOIA'd. Discovery closes. I wouldn't have any faith that Canton's going to miraculously have this done before the close of discovery in this case. In fact, I would be concerned that they would be like, oh, take your time. We don't want that report. Date 30 days after discovery closes. So they go on to say that it appears that the majority of the information sought by the defendant has already been obtained by the defendant. How do you know that, though? The basis of the pending investigation involves text communications involving multiple individuals, including Sergeant Goode. Those text communications are at the heart of several other pending matters and are subject to protective order. The defendant's motion appears to assert that the defendant has already obtained those text communications as newly received documents from the Norfolk District Attorney's Office. No, I think that only goes to Proctor's phone. Also, in this case, if in any case, what text messages still exist on Proctor's phone or anyone in the house's phone and what's on Goode's phone might not all be the same. Have we not learned by now that the delete your shit in all of this is strong? They need both sides of all the conversations to see what, if anything, was deleted and how much was deleted. It's a huge factor in this case. The town maintains that disseminating internal affairs investigation materials at this time is improper and harmful to the pending investigation. I don't think it's harmful to the pending investigation if it's under a protective order. The defendant's subpoena is overly broad and is moot, given the records already obtained. The court must therefore deny the motion to compel, or at the very least, significantly narrow and limit its scope. Any such responsive records are issued under seal or protective order. I agree with that part. Look, we found one. I agree with that part. I think issuing it under seal or protective order is appropriate if it's an ongoing investigation. Not everything should be, but I think some seal or protective order is appropriate. Let's see what the defense had to say as we tee this up before it goes to hearing, early next month. I guess we're already almost at the end of April. Defendant Karen Reed's reply in support of a motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. Your Honor, give us the discovery. It's not going to burden the town. Summary of the first sentence. Reed's subpoena to the town seeks disciplinary records relating to Sergeant Goode, including documents gathered as part of CPD's investigation of Sergeant Goode's troubling communications with former State Trooper Michael Proctor, who was the lead detective of the O'Keefe investigation and arrested Reed. Right. Indeed, CPD's investigation into Goode came in the aftermath of a jury finding Reed innocent of all charges relating to O'Keefe's death and the discovery of thousands of messages on Proctor's phone, including many to and from Goode. Goode and Proctor have been close friends for over a decade and were or are part of a small group chat in which they shared messages with each other about various topics. Was one of those topics this case in Karen Reed? I bet it was. The disciplinary history of one of the first officers on scene and his relationship with the lead detective on the case are directly relevant to the nature and reliability of the investigation, which is at the core of a number of plaintiffs' claims. As a result, the documents are well within the scope of discovery. Also, Canton was conflicted out. If Goode is continuing to have conversations with Proctor, a jury might be more readily able to find that tainted the investigation because it gives them a boundary. They were conflicted out. They were out of this investigation. And yet one of the first responding officers is still talking to the lead agent. If that was happening, it's very relevant to a jury in the assertion and defense of this case that the investigation was biased from the beginning. Obviously. Finally, the town's opposition contains a number of mischaracterizations of the parties' conversations and Reed's attempts to comply with Rule 9C. Attached as Exhibit 1 are 2 email chains that reflect those attempts. Thank you, counsel, for attaching the emails. Do we always want to see the emails? Yeah, we fucking do. We always want to see the emails. February 10th, David Chris, thanks for the time last week. Oh, they did speak. Okay, thanks for the time last week. As we discussed, attached is a second, more discreet subpoena specifically relating to the investigation into Sergeant Goode, any misconduct and communications between Goode and the relevant individuals in our case. Please confirm that you accept service of this subpoena on behalf of the Town of Canton, Canton Police Department. During our call last week, look, this is exactly what you should do. During our call last week, I explained that I had given the town the benefit of the doubt when Jamie told me that the town, including its counsel, did not possess further documents that would be responsive to requests like this. It sounds like the town may now possess at least some such documents, and they need to be produced. I understand that the town has some concern about disclosing documents relevant to an active investigation. Although that is not a valid objection to a properly issued subpoena in a civil case, I am willing, as I said on the phone, to consider limited confidentiality restrictions on those documents, which would be effective until the investigation is completed. If you would like to propose such restrictions, let me know. Otherwise, please produce the documents. I mean, I summarized that last sentence, but yeah, please produce the document. It goes on to say, February 11th, so this is the next day, from Aaron to Canton lawyers. Please confirm today that you accept service of the attached subpoena. Otherwise, we will serve the department directly. There are some things that just feel so dumb and gamified. But when you are counsel of record for the city of Canton, not just responding, obviously, yes, we accept service, is so frustrating. It goes on to say, from David responding to Aaron, February 11th, yes, as discussed, I accept service on behalf of the Canton Police Department. My office is coordinating with the department, and I will hopefully be able to follow up with you shortly regarding the subpoena. Okay, at least it's a response. This is from February 20th. David, I assume the attached email letter means that you are now refusing to provide any documents in response to this subpoena, even if we agree to confidentiality provisions. Despite our numerous attempts to confer, our offer to work with you to address your client's concerns and your colleague's prior statement to me that the documents in question do not exist in the department or town's possession, custody, or control, which your letter does not assert, please confirm that I understand your response correctly. And if so, please let me know when you are available Monday to confer pursuant to Rule 9C in advance of immediate motion to compel, as Judge Goode has urged us to do in this case, which we all watched the judge do at that hearing where the judge was like, bring it to me. Bring it to me. February 20th, enclosed, please find the Canton Police Department's objections to the subpoena regarding the above referenced matter. A physical copy has been mailed to your attention as well. I'm sorry, where's the barrage of emails? Attached is defendant Karen Reed's motion to compel the Town of Canton to produce documents pursuant to non-party subpoena and her motion of law in support. I understand from our previous phone conversations and email exchanges that you are not willing to produce any documents in response to the relevant subpoena. If I am incorrect, or if you believe further conversation pursuant to Rule 9C would be productive, please let me know and I'd be happy to schedule a time. Hey, we have an obligation to meet and confer so that we can try to work this out before we drag the court into it. Like, don't go to mom unless that you have to. Try to work it out. Are you going to turn things over? No, great, done. So where are we at? Well, we're at the Town of Canton objecting to turning over the documents regarding Sergeant Goode's investigation. But I understand why they're asking for it. In this lawsuit, where the O'Keefes are suing Karen Reed for wrongful death, her defense is A, I did not kill John O'Keefe. B, the people who could have found out who killed John O'Keefe did not do an investigation. It is part of her defenses. And the disciplinary action that seems to me to be a ripple effect from all of this, and maybe it's not. Maybe the vile text messages are not related to this case at all. Maybe they're not, but they have a right to see when the ripple effect seems to be directly related to Karen Reed's case, because you're not getting into Proctor's personal phone if not related to this case. Proctor was terminated in relation to his duties in this case. Goode has now been suspended. He was on this case before Canton was conflicted out of this case and is close friends with Proctor, who was fired because of his behavior in this case, in part because of text messages. It all seems connected to me. And if it's not, the Reed parties have the right, I think, to be able to evaluate the investigation into Goode and argue whether or not it's connected. I don't think the Town of Canton gets to be the gatekeeper here. This is not a criminal case. This is a civil case. there is broader discovery, and there are mechanisms that if it's not related, the court ultimately can hear the arguments on both sides and decide to bring it in or keep it out. But everything in this case is such a fight. We know that there are going to be and continue to be more fallout from these cases. And we've seen it. We've seen the fallout continue. So I'm not surprised that this is such a fight. And maybe it's why Proctor hasn't requested documents in this case. So this hearing at this time, as of recording today, we are going to expect that the hearing on the motion to compel will be held on Tuesday, May 5th. And we'll see what discovery will be turned over with regard to Sergeant Sean Goode, because it's not looking good for him. I imagine that Sergeant Goode is not the only domino that's going to continue to fall in the fallout from whatever the fuck Trooper Proctor was doing on his phone. And maybe some have retired before that fallout smacks them roundly in the face. Maybe not. Because you can't terminate someone that has retired. But that is rampant speculation and quandary on my end. Just a matter of curiosity. So what happens now? Well, we are going to see this case continue to be fought over discovery. There are a few other items in the civil case we haven't circled back to that we will circle back to as we start getting rulings here. So as we start getting rulings in this civil case, we will look at it. I am keeping an eye on the Proctor phone problems and on Proctor's my memory, Your Honor. Can you please grant me limited discovery? Please, 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 please. Because I'm curious what's going to happen. And as we know, Karen Reed has said she is going to be suing Canton and MSP. So when Karen Reed's attorney said she was going to sue everybody, she's going to sue everybody. And we are going to continue following it. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.